Good morning, Mr. Co-Chairs and esteemed committee members. Brianna January with Chamber of Progress in strong support of SB 1249. Chamber of Progress is a tech industry coalition advocating for the progressive future of tech and inclusive access to that future. Our partners do include household names like Amazon, Apple, and Google, as well as smaller AI innovators, but I will note that they do not have a vote or veto on our positions. Committee, AI has the tremendous potential for improving education, enabling creative expression, and creating new business opportunities. So it's critically important to us that public policy promotes the broad and equitable distribution of these innovations. And we believe that the governor's prioritization of developing AI in Connecticut, as set forth in both his proposed budget and the mechanisms of SB 1249, do so, and that it's the correct balance and will drive the Commonwealth as a model state for the region. In fact, Commissioner O'Keefe's testimony earlier outlined the exact approach that Chamber of Progress encourages public bodies to take regarding potential bias, and we thank the Governor and Commissioner for advancing this thoughtful policy. In particular, we support SB 1249's creative innovation through AI regulatory sandboxing, the streamlining of data management for agency efficiency, and for providing economic growth through the AI Investment Fund. We strongly encourage your support for SB 1249, and we look forward to working with the Commonwealth to implement the governor's AI proposals. I would also like to quickly comment on SB 1248 and suggest a few small amendments to improve the bill for both residents and the industry alike. As drafted, SB 1248 does not reflect the complexity of some three-sided online marketplaces and could risk unfairly penalizing platforms for third-party listings. In three-sided online marketplaces, whether they be lodging rentals, home sharing platforms, independent sellers offer and set the prices for their goods and services. The market operator themselves then connects those independent sellers with customers, and they may offer additional services like processing, safety checks, identity verification. In those sort of marketplaces, the sellers set the prices posted on the marketplace platform. So SB 1248 as drafted, the platforms could be held liable if a hotel or resort, for example, failed to incorporate all resort fees or applicable taxes into the price posted on their platform, but yet it would be that third-party seller that would still be held accountable. This could easily be addressed just by simply including a safe harbor provision that says that three-sided marketplaces and platforms that do not independently set the full price, such as those that I've just mentioned, that they are not held liable in case a hotel or resort, for example, fails to set all of those pricings. We're essentially requesting just clarification there that third-party platforms will not be held liable for external parties' failures to include all relevant fees. And then lastly, committee, in section 2, the bill requires additional disclosures and cancellation mechanisms, which in practice could make it harder for businesses to offer special deals or flexible services, discounts, etc. This could also then increase the
3 minutes are up. Would you mind summarizing, and then we'll go to
questions? Absolutely. We're just requesting a simple amendment that would maintain both consumer choice and transparency while making sure that prices are not overly exploited for consumers. Thank you.
Great, thank you. And you're going to submit written testimony as well, correct?
We already have, correct.
Okay, great. Thank you. Are there any questions from the committee? Representative Lamar.
Thank you, Ms. January, for your testimony. Specifically with regards to 1248, I'm interested in some of the concerns you recognize regarding three-sided transactions. To me, like, again, the paramount concern is the Connecticut consumer who's subject to the lack of coherence between one party and a second party when they're making that purchase and how they go through the process. So I actually want to hear through ways that we can resolve that inherent conflict between the protections that we want to have in place for our consumers versus the challenges that two sides of that party may place. And so I think there's a space that both protects what your concerns are and how it's implemented, but also gets to our ultimate concern, which is the Connecticut consumer's experience. So I look forward to your conversations with respect to 1248. 1249, I'm certain my co-chair will have greater conversations on that bill, but I just wanted to preempt that conversation with a willingness to work with you on 1248. Thank you.
Thank you so much, sir.
Thank you. Are there other questions? Otherwise, I'll go into my questions. Thank you very much for coming to testify. You've been here to testify a number of times, I believe, in the past, or at least the Chamber of Progress has been here to testify. And I think this is the first time you are testifying in support of a bill instead of opposed to a bill. Am I correct on that?
For this session, that might be the case. There are surely other bills that we are supporting in the works, but this one is one that we are particularly pleased with.
Okay, great, thank you. And I noticed you were at it. Were you invited here to testify in favor of this bill?
The governor's office did reach out to seek support, but we had already planned to do so, to be perfectly honest.
Okay, great, thank you. Last time you were here, you were testifying against the AG social media feed bill. And again, let's go back. You started with some of your members. At that time, you named some of the members who funded the organization. Would you mind just sharing that list again?
Absolutely, I'd be happy to. We are a tech industry association that I'm sure you're familiar with other models. We are different from your traditional model. Our members are not actually members, they're partners. They include folks like Apple, Google, Amazon, Uber, etc. But they don't have a vote or veto on our positions. We actually lead from a center-left position as a staff, and we make our own position decisions.
Great. Is Meta also a member?
They are not actually. They partner with us for some European work, but not for domestic.
Okay, great. So, but a lot of those companies you mentioned, right, Amazon, et cetera, it would be safe to say they're tech billionaires, some of the leaders of those companies.
Absolutely, they are.
Great. Okay, thank you. Now, one of the things about the approach, and I think sometimes bills can be brilliant in their simplicity, and a good example of that would be last year, Illinois had a law that said that you could not. So the opposite of where we're going with this bill and where we're saying that AI is not a defense against discrimination, they went more proactive and said that you cannot use AI to discriminate, which then implied that you would have to test it before you're using it. Now, one of the things here is that we're introducing and we're saying it's not a defense, and we're relying on CUTPA, which is the Connecticut Uniform Trade Practices Act. That allows for a private right of action. And so it would allow for people to sue Connecticut businesses. Usually tech companies testify against bills that introduce a private right of action. The last one that actually passed with the private right of action was 2008, Illinois' Biometric Information Protection Act. I was wondering if you could share some of your thoughts on what has happened because of the BIPA law.
That's an excellent question. I would love to gather some thoughts more appropriately with some colleagues and get back to you in writing, perhaps. I will say that we have been engaged all over the country on private rights of action laws as well as anti-bias and AI laws. Our approach is very much similar to what the commissioner outlined, which is we have no difference in our approach, whether it's human-based or algorithmic-based discrimination. We think that it's more appropriate to look at a state's existing anti-bias laws. And if there are any sort of loopholes that could be used by AI and algorithms, let's close those loopholes where they exist, because we don't care, again, if it's a human making decision, if it's the human inputting data into an algorithm that ultimately makes the decision. We want to get to the issue where it exists without stifling innovation overall.
Great. Now, due to the black box nature of AI, right, we don't require explainability. It's part of the White House's blueprint for the AI Bill of Rights to allow for explainability. But right now, sometimes we don't know how it's making the decision. How would we know if it's discriminating if we don't know the process of how it's making the decision?
That's a great question. And we support having testing done for AI data and training. I'll note that the governor's proposed approach to have kind of a set of data that can be used to help inform AI training models is an appropriate one. I would be concerned to make sure that we're having a robust input for who is selecting which data is to be used for that public availability. Training is important, and that's exactly why we're appreciative of the fact that this proposal includes a safe harbor, because ultimately we want to make sure that as companies are testing to make sure that their data is not biased, that if they find that there is some sort of issue, that they're able to, in good faith, fix that and not be in fear of having liable legal action when they're doing what they're supposed to do under a proposal like this, which is to find those issues, to fix them under good faith, and then get the data in a way that can be appropriately used without bias. So the safe harbor is really critical for us.
Okay, and so I think we have some areas of agreement here. We agree on
Absolutely.
testing, and it sounds like you agree on data transparency because you need to know the
1000%.
system is properly trained.
Absolutely, sir. 1000%.
Okay, great. Thank you so much. Now, back to the BIPA law. It was passed in 2008. It took till 2019 before the first court ruling came out. And according to actually the Chamber of Progress did a great study on the BIPA law. According to your research from your organization, after that court decision came out in 2019 on how you could measure instances of harm, what constituted harm, lawsuits increased by 1,400%. After that. So there was a significant increase in lawsuits from 2019 till the present. The first one was just settled. Now, this bill, it seems to rely on litigation rather than legislation again, because Uniform Trade Practices Act has that private right of action. And it says that AI is not a defense for discrimination. So in some ways, that takes the liability off of the developers, the out-of-state developers, and puts it on Connecticut's small businesses. It seems interesting that you're coming from an organization that's funded by these developers, and you're testifying to put the liability on our small businesses.
Thank you for that observation. I'd like to clarify that our members are some of the larger AI innovators, but they're also startups. They're also folks that have barely come into the marketplace and that are looking to make a splash. That said, the balance that we think this bill strikes is one that makes sure that those smaller innovators are not left out of the Connecticut market. Our fear is that overregulation will do just that. It'll ultimately end up creating a monopoly in which you only have the Amazons and the Apples and the Googles that are able to operate in the state because smaller innovators aren't able to keep up with the logistical, the administrative burden around testing, around the possible legal liability that they simply would not be able to afford to pay. And that's whether those smaller innovators are Connecticut based or not. We think that this is the correct approach to balancing that. Small innovators are very much at a forefront of our approach to public policy and are members of ours as well. But we'd love to work with the committee to ensure that that balance is more appropriate if you don't feel that it's struck appropriately here in this language.
Yeah, and agreed that we need to offer, we want to incentivize responsible AI innovation. We want to offer a pathway to compliance and provide tools for our small businesses. And this, I guess, will be my last question. Businesses and small businesses, all businesses really, they're developing a product that they want to sell, right? They need customers. Again, this approach seems to put the liability all on the customers. But one of the things I'd ask if you're familiar with the Boston Consulting Group study from last year, January of 2024, where it said that 62% of the people they surveyed, 62% of the businesses that they surveyed were holding off on fully investing in AI until there were clearer government regulations.
I'm not familiar with that particular study, but that's exactly what we hear as well. I'll note that we share the concerns that the commissioner outlined earlier, that a patchwork of state law is exactly what will prohibit those smaller innovators from being able to comply all around the country and to enter marketplaces. So whether we take a regional approach that is more balanced to making sure that we can limit bias as much as possible, whether again it be by an algorithm or a human decision maker, and making sure that we can empower smaller innovators, or we take a state-by-state approach like we're seeing right now, but the overregulation of patchwork, especially in the Northeast with smaller states and with such regional cooperation in other economic areas, is extremely challenging for those smaller innovators for that very reason. So I'm not surprised by that data.
Right, and so that sounds like we're agreed that a regional approach to provide clear regulations and guidelines, and not even regulations, we're looking to provide guardrails, right, to protect against unwanted bias or discrimination.
Absolutely. We'd be happy to look at that approach. I am the director for the Northeast Government Relations for Chamber of Progress, so I am doing just that, working. Our definition of Northeast is a little generous. I'm working from Virginia all the way up to Vermont, as well as a little bit west. So I'd be happy to chat with the committee on how we can take that approach as well. Obviously, state level regulation can also be complementary to a regional approach.
Great, thank you. And I believe Virginia does have a bill that it made it out of the House and is poised to make it out of the Senate in the next week. So great,
I've
thank
been
you so
engaged,
much
yes.
for coming to testify, and I'm sure we'll be seeing you in a couple of weeks.
Just next week, I believe. Thank you so much, sir.
Okay, goodbye.